Hi, Corey Stack here again. There's a huge amount of interest in my work on the Protective Disclosures Act, and I have several papers up on academia.edu, and I'm working on a final draft of a really good paper, I think, at the moment. And this is just one of the angles I'm looking at in it, and I've been working on this for many years, and I've taken it up again in the last couple of months. But for every paper, there's another question, so it has infinite. There's infinite possibilities here in terms of research. So let's just look at this angle here, and it's most concerning, particularly in view of the statements made by Mr. McGuinness and Mr. O'Flynn, and then Mr. Eddie Hobbs interviewing Miss Una McGurk on his Counterpoint program, and many other people. But there is also, serious concern raised about various whistleblowers and the way they have been abysmally treated. And one of the points that I made in my research was that really there was a huge problem with design here, and so I'm going to focus on that, the design of the Amendment Act, and I'm going to make a strong statement about how the extent to which I think the design is highly questionable and very 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 wrong in terms of the points I'm going to make. And so this is going to be perhaps something we really need to examine very carefully, our consciences with regard to this, particularly the designers of the Act. And so designed to protect institutions, how Ireland's whistleblowing system was diluted. So this is now in the 2022 Amendment Act, or Act as amended. So Ireland's protective disclosure system was created to protect workers who report wrongdoing. That was the intention. That's an EU, from the EU, comes from our, that the EU are sort of people we have to report to and abide by their, overriding regulations and rules and so on. So, but over the last decade, something very different has happened. This is not a system that is failing by accident. This is a system operating exactly as it was designed, to protect institutions, not truth tellers. So I prefer to use the word truth tellers rather than whistleblowers. It's kind of a derogatory word, but I prefer to use truth tellers. So the shift away from protection. In 2014, Ireland promised whistleblowers safety, fairness, and independent handling. In fact, it was hailed as one of the best and strongest whistleblowing acts, in Europe, if not the world, at the time by OECD. But today, workers who raise concerns face a very different reality, and I'm telling it as it is. This is exactly the way it is. It's a very different reality. Across policing, healthcare, universities, local authorities and the public sector, one pattern repeats. The whistleblower becomes the problem almost immediately, not the wrongdoing. So that's one of the first things. And that's created by the design and by the what's now embedded in the Act in terms of how the institution should respond to the Act, and that in itself, I think, is highly questionable, more than highly questionable. So what I'm going to call this, burden reversal. This strategy, burden reversal, the core structural failure. So burden reversal is the heart of the problem, and it's our personality switching and a personality disorder. So instead of investigating the issue, institutions investigate the individual almost immediately because of the design. The design allows the switching from the issue, which is being disclosed as the wrongdoing, to almost immediately saying the person disclosing the wrongdoing is the person with the problem. See, it's called the projection in narcissism or in severe cluster B pathology. So instead of investigating the issue, individuals investigate the institutions investigating. It's almost immediate by the design. There's a time there in which there's the switching, and I'm calling it burden reversal. So cutaways, paperwork, HR meetings, closed door, stress, isolation. The workers' motives. Behaviour, tone, personality. So this is the burden reversal, shifting, even their emotional distress. Now, very few whistleblowers are going to, report whistleblowing without being severely distressed. So that comes with the, with whistleblowing, a very distressed worker under the, the definition of worker under the Act. So the worker's motives, behaviour, tone, personality. I mean, somebody's going to make a whistleblowing complaint unless they're represented, by a legal team. Even their emotional distress all become ammunition used against them. They're immediately targeted as, off the wall, because the system response gives the advantage to the institution by design. The disclosure can be framed as a grievance. Typically what happens is the first question is, you're not a worker, and this is not, the whole burden of proof is not on the body that the disclosure is disclosed to, but immediately you see the burden reversal. The first question is, you're not a worker, and that's not a statutory statement. So that should be proved in a court, or a tribunal, but that's usually the first wall of defence, and that is the first real evidence of burden reversal. You're not a worker, even though they have no statutory. That's not a statutory statement, so they have no right to say that, and that's their first gatekeeping. Strategy. So the concern becomes then either an interpersonal issue, or it's nothing to do with us, and so on. It's interpersonal. The truth teller becomes the target. So these are the common tactics that are used. So this is not, but particularly the gatekeeping. So if you can close the gate before the investigation goes any further, and then if you ask for procedures, only the best of firms will give you procedures, and most of them won't give you other procedures. It'll be ad hoc. They'll make it up themselves, and they'll investigate themselves. So they'll shield themselves from all investigations. And I have evidence that, people that have made disclosures to investigate themselves, and they think that's okay because there's no follow-up. And there's no one to sort of complain that they're investigating themselves and they're making it up as they go along, allegedly. And they'll get, maybe a solicitor or a junior staff member to write a whole load of, and leave out a whole load of things, this sort of thing. And this is considered, professional behaviour by academics or others who could be paid an absolute fortune on an annual basis to run organisations, or chairs, boards, and things like that, or wherever these disclosures go to. It's the predictable outcome of letting institutions across disclosures made against themselves. So let me say that this is what kind of an oversight system is this? This is not accidental. It is the predictable outcome of letting institutions assess disclosures made against themselves. So they can assess disclosures made against themselves, and that's allowed by the Act. So the amended Act, how the legislation was diluted. The 2022 amendment made things worse. So what you had is internal handling mandatory. I mean, that's highly questionable. Independent investigations optional. Conflicted outsourcing allowed. No trauma-informed practice. No sanctions for retaliation. Longer timelines. Zero enforcement. In particular, there are longer timelines. That's highly questionable in terms of any kind of compliance with any kind of reasonable whistleblowing policy. All of that is highly. All of that, from a compliance perspective, if you were a compliance expert, you'd have to say that each of those is highly questionable, and these are now embedded into the Act. So legally, this is this is godsmackingly, unbelievably problematic compliance-wise. Like if we were a compliance expert, that's maybe my next place to look at compliance. I'm interested in compliance. Yeah. Presented. Oh yeah. So presented as the compliance with EU rules, the amendment actually strengthened institutional control and weakened worker protection. So let me say that again, because I think this is important as a key part of the dilution. Can be described as presented as compliance with EU rules, like the hypocrisy of it. The amendment actually strengthened institutional control and weakened protections, and that is presented as compliance with the rules. I mean, that is hypocrisy of the highest order, allegedly, and deeply concerning. So I mean, I'm not explaining in very simple language so the public and the public servants understand it, in very plain language. And I couldn't make it clearer because it is very complex, and my papers are available on academia. I'm trying to just, give bite sides. It's so complex, you see. If it wasn't complex, everybody would understand it. So I'm trying to reduce it into sort of bite size. Even some of the feedback I'm getting saying it isn't bite sized enough. But I mean, when it's this complex, you see, it's the whole idea is to blind people with law and shielding and all of this, and they don't know what their rights are. And that's exactly what's going on, So institutional shielding. And so let me look at another aspect here. Institutional shielding, systemic pattern. So internal handling. This is the whole point of institutions investigating themselves. Internal handling means institutions set the narrative. This is exactly what happens. Delay becomes a strategy. Documents go missing. And timelines stretch into months or years. Narratives, this is very important now, narratives are manipulated to minimise risk and protect reputations. So you might get some kind of a letter back, and you can almost see the manipulation and the gaslighting, and you can see how that letter is designed and manipulated to reduce or minimise risk and protect reputations. And if you ask any questions, the delay is the answer. Silence will be your answer. So that's very important, that that they have so much control over the narrative that they can manipulate the narrative. And the whole idea of manipulating the narrative is to minimise the risks, not tell the truth, just half truths or twisted truths. And it's designed to protect reputation. So the whole thing is institutional shielding. So this is what has come out of this new EU compliant new act, amended act. And when external investigations are brought in, there are already often have financial ties to the organisation. So in theory, they look like, well, they're outside, they're outside the organisation, but in fact, they could have several, other contracts with these organisations, which automatically brings in the whole area of conflict of interest. And obviously, if there's conflict of interest, these people are almost inevitably going to find ways to side with the institution. Again, a major compliance issue there. So this is not independence. This is institutional shielding. What kind of designers of an act allowed all of this? I mean, they knew this when they designed it. Like it was like a penalisation of whistleblowers in the Whistleblowing Act. That's what I call it. Inbuilt penalisation of whistleblowers in the Whistleblowing Act. Cronyism, conflicts and collusion. Ireland's public governance offerings, as we all know, operates through tight networks. The same firms, the same consultants, the same lawyers that appear again and again. So we all know that. When the investigators depend on the institution for future contracts, true independence is impossible. Now, this is very much characteristic of not just the protective disclosures, but all oversight investigations. You have a small set of investigators, and they're dependent on the oversight. Investigation. So again, there's conflict of interest there, because if they side against the institution, even the interest of the right, they won't get the next contract. So this is the problem. There isn't enough investigators, and the few that are financially tied, and they're tied to siding with the organisation, even though they're supposed to be independent investigators. So the whole compliance and regulatory framework over all of these are hugely problematic. Which is what I'm saying is we need a new system of arbitration first before we waste so much money on all of this very very, very highly questionable oversight systems, where you have the same set of investigators, doing the circles and doing the rounds, and they cannot side against the institution, because if they don't, they won't get the next. They won't get the next. They won't get the next contract, and so this is the conflict of interest. But it has huge impacts on accountability, massive. So this system is doomed to failure. Doomed to failure, to quote a particular recent judgment. So the capacity gap. So when the investigators depend on the institution for future contracts, and there's a huge amount of these, small amount of investigators, but they're very dependent on these contracts, and they're outside contractors, but there's a huge amount of these contractors. Now there's also legal firms. A huge amount of legal firms, consultancy firms, accounting firms, they're hugely dependent on the state for funding. So they really are all arms of the state, really. So they're hardly going to side against them. When they're, like it's who pays the piper calls the tune, but I mean, it's the taxpayer that's paying. You see, these people think it's the institution or the institutional team. It's not. It's the taxpayer that's funding all of these investigations. But they're, if the people in charge are there permanently or almost permanently, they'll penalise them. So the penalisation is, it works lots of different ways. It works against even the investigator, in a lot of cases, because he'll be or she'll be penalised if he tells the truth. So that's a double whammy there. Not mind the disclosure, but the person investigating it is probably terrified as well of the penalisation that they'll be exposed to if they expose the truth, in a situation. So let's call it what it is. It's a failed system, and we need a different oversight system and a different system of accountability. So I'm saying we should have a trauma-informed arbitration first for as many of these kind of complaint systems as we can. And I'm saying we should start with the justice system. But I can see the whole thing it's from a regulatory point of view, it's a complete failure. It's doomed to failure from a regulatory point of view or compliance point of view. So the capacity gap, this is a major issue too. We cannot investigate ourselves. Wrongdoing today is highly complex. Procurement, finance, governance, regulatory breaches, abuse of authority, just to name a few. Yet institutions often assign these cases to HR staff, junior administrators and consultants who simply lack the skill set required. I mean, you'd have to be a forensic investigator or somebody like of the standard of the CBI, criminal university. And how long is that going to take? One investigation is going to take a huge amount of time and resources, and inevitably, the system is overwhelmed with complaints. So loads of them will be gaslighted, and all these whistleblowers will think that that their reality will be distorted because the capacity isn't there. So this system, what I'm saying, is not going to work, and this is why I'm saying our protective disclosure system, it can't work because similar systems are failing. All the time we're having all of this because the systems, there's a huge capacity gap, and essentially what's happening is institutions are essentially investigating themselves. Even if there is so-called independent investigators, they really cannot, because they will not get the next. They will not get the next, contract, and their bread and butter is dependent on this. So this is a failed system. This is the point I'm trying to make now, So yet institutions, yes, they assign these very complex cases to HR staff, who wouldn't have forensic investigative powers or abilities junior administrators or consultants who completely lack the kind of complexity or the forensic mindset that would require to really tackle these. And inevitably these will be gaslighted because, they're not able. And gaslighting becomes, all this gatekeeping and this shielding and everything. I mean, even the shielding, there's a little bit of cleverness behind the shielding, but the gatekeeping is well, it's a very poor law. If it's legal people that are writing, you're not a worker, and they know that that's not a statutory statement. This isn't just incompetence; it becomes a structural defence mechanism. Now, let me look at the emotional side of this. How this affects. This is what was very clear, in the Dáil this week through the representations of Mr. Flynn in particular, Mr. McGuinness, and conversations with Mr. Eddie Hobbs and Ms. Una McGurk. So I understand this very well. So trauma and re-traumatisation. So the greatest, and we saw this on Primetime Investigates a few years ago. It was harrowing, but it hasn't changed a bit. If anything, it's got worse. Trauma and re-traumatisation. The greatest harm rarely comes from the wrongdoing itself, but from the institutional response. And this now is almost embedded in the design of the new legislation. This was made by Mr. Flynn in particular. Silencing, these are the tactics: delay, disbelief, character attacks, and that burden reversal, that's like projection in a personality dysfunction. These mirror the dynamics of coercive control. I've studied this for years. I've studied, narcissism for years, and so this is, but like the psychological narcissism. I've studied that for many years, maybe 10 years. I've studied this, so this is very clear to me. You have the individual narcissism, and you have the institutional narcissism, and that's what I think has hit the Burkes, the institutional control. It's all control. The Burkes are dealing with a huge amount of control, but it's like whistleblowers. They're like kind of whistleblower. They're treated like whistleblowers in a way. In this kind of coercive control, that was subject to coercive control, in my opinion. I mean, this is very objective now, just looking at it. As I say, I don't know the Burkes at all, but I'm watching the story like everybody else, and I feel that it's way beyond where it should be. This should have been, brought to arbitration at the very beginning. But I suspect there was more to it than just, what was presented as the narrative to the media, or what the media presented to the narrative to the rest of us. But I'm not sure. Maybe the media weren't fully aware of what was going on behind the scenes. But I mean, I think you have to look at all sides. And when you're a reporter, you shouldn't just take a one-line narrative. Whistleblowers are re-traumatised by the very process meant to protect them. The courts, where imbalance is reinforced. Then, supposing this goes to court, let's see what happens when this goes to court. Judicial culture compounds the problem. There is deference towards states' bodies, so this would be something that would be well known. That courts, there's overly deference towards state bodies, even though where there is separation of powers, because a lot of judges are appointed by the state. So, it's inevitable again that there's conflict of interest there, and it can be worse. Like, it can be a lot worse than that. There's an extraordinary burden of proof placed on whistleblowers. I mean, that's totally unfair. There is an adversarial litigation. There's adversarial litigation against people who often have no legal representation at all. So that's the same thing as lay litigants. Lay litigants are treated as a nuisance. And, so if you're trying to go to the court to get any kind of redress from penalisation, you're facing an impossible battle. A system already imbalanced becomes in a courtroom almost impossible to overcome. So these are very serious issues. Cross-sector patterns, proof of a systemic problem. So if you're looking at either garlic whistleblowers or healthcare scandals or scandals with toothless childcare issues. We have the CAMs. We have all of the institutional abuse scandals over all the years. We have the startups. We have so many of these scandals, local authority corruption cases, and so on. All of these across every sector, the same pattern emergence. I mean, it really is the same: delay, denial, deflection, and retaliation. So this is repeated across all these sectors. This is not anecdotal, it's structural. So I'm suggesting now a solution. Again, I'm going back to the trauma-informed independent authority. So I'm trying to take the whistleblowing. We cannot investigate ourselves, and even if there's any hint of a conflict of interest, there's a huge problem. And I'm still trying to find something that's genuinely it does not have a conflict. It's almost impossible to find something that doesn't have some kind of a conflict because of this: who is paying the investigator. So the solution, a trauma-informed, the taxpayer is. But you see, because people are dependent on the same senior management perhaps for a number of years, they're almost afraid to speak out against the institution. And it takes a lot of courage to do it, if they do, a huge amount of courage. So let's look at this again. The solution, a trauma-informed independent authority. Minor reforms will not fix this. We need an independent, trauma-informed whistleblowing authority. I suppose it would be a little bit like the workplace. Our workplace commission. So the WRC, sorry, the WRC, the Workplace Relations Commission, but specifically for whistleblowing. And this is where in the investigations of trauma-informed whistleblowing authority. So we should have. This is just another suggestion. I've suggested a number of them, but let's look at this one: an independent trauma-informed whistleblowing authority. So, and the features that would be involved here are independent intake, expert investigators. I mean, do we have those in Ireland? Independent, immediate anti-retaliation measures, transparent reporting, no conflict of interest, trauma-informed practice at every stage. So I'm kind of looking at this for all dispute resolution. And each of those, if you just look at them again, are independent intake, expert investigators, immediate anti-retaliation measures, no conflict of interest, and trauma-informed practice at every stage. I mean, that's proper compliance, and that's proper kind of conflict resolution. There's ethics, there's morals, there's compliance, there's an understanding of the trauma element of whistleblowing. That's proper design, in my opinion, and it's as independent as you could possibly. And why isn't that in the design? Like people there that designing these, do they not ever think of, like, if it was their son or daughter, say, that was making the disclosure, how would they feel if it was someone belonging to them that was making the whistleblowing disclosure? Do they put themselves ever in the shoes of the whistleblower, or are they just always thinking of the institution? It could be their relative, their nephew, their niece, their daughter, in the next generation or in the next generation. Do they ever put themselves in the whistleblower's shoes? Because to me, there's a huge lack of empathy. And this is always associated with the high narcissistic spectrum and coercive control. No empathy. And there's a kind of sadism in it when it's coercive control like this. There's sadism. I mean, that's a very strong word, but that's how I see all these delays and all these sort of things that'll really upset them. It's as if that delay will upset them there, that obstruction there, that's there. Everything is designed to cause maximum harm and trauma and pay them back. So you're punishing them. So there's punishment in the design. So this is how I see it. So I'm looking at the emotional side, and I see punishment, trauma, penalisation, vindictiveness embedded into the act. And this is incredibly harmful to the person. And it's severe penalisation, and, the action itself is penalising. It's inevitably going to penalise because it's really coercive control in the act. So it's shocking when you really look at it in that sense. Absolutely shocking that anyone would design an act which is coercively controlling in its design. So this is the only so to switch it from coercive control, again I'm going back to the collaborative, the cooperative, the compromise, all of that, and to have it, to have the independent intake, expert investigators, of which there are very few, independent anti-retaliation measures, transparent reporting, no conflicts of interest, trauma-informed practice at every stage. So this is the only viable way to restore fairness, accuracy, and democratic accountability. So final message, a choice for Ireland. A system designed to protect institutions simply cannot protect whistleblowers. And that's what we have at the moment. And not worse than that, it's penalising whistleblowers in a way that is tantamount to coercive control. And that's beyond shocking. But I think if we know that, perhaps we know what we have to do to fix it. That's how much we have to do to fix it. I mean, that's how where it is now. That's what we have, that's our place of zero. That's worse than zero to fix it. I mean, it's a huge job to fix it if this is where it is now. So be under no illusion that the Act now is tantamount to coercive control on the whistleblower. Allegedly, that's all. That if you just look at the ingredients of the Act, it's designed to coercively control, allegedly, the whistleblower. And would you call that whistleblower protection? And when whistleblowers are not protected, the entire public suffers because wrongdoing becomes invisible. Well, it's the wrongdoing comes from the Act itself. Ireland must now decide: do we preserve institutional protection and an act which in intent is allegedly coercion or coercive control, or do we change to protect truth, democracy and public trust? Whistleblowers are not the problem, they're the safeguard. So that's where I'm at now in terms of my analysis of the Act, that in fact what we're dealing with is an Act which has allegedly coercion or coercive control in its design, and it is no wonder that the likes of Mr. Flynn, Mr. McGuinness and Mr. Hobbs and all those other people are talking about how traumatizing it is for whistleblowers and how much they've suffered, because they have suffered institutional coercive control by design. So there's a job of work to be done to sort this out by the Irish Supreme Court.